So first and foremost, most companies, no matter how big or small, are probably offering their product or service under a particular name, and that name could very well be functioning as a trademark in the minds of the public. And if that's the case, people should think about applying to register their mark, get protection in place so that they can stop third parties from copying their mark. So here's the science bit, as they say. What is a trademark? Well, the legal definition is any sign capable of being represented graphically, which is capable of distinguishing the goods or services of one undertaking from those of other undertakings. More succinctly, it's often referred to as a badge of origin. So people, upon seeing a particular trademark, will associate that particular product with your company. So what they are not, and this is probably very important in everyday practice, I often hear, oh yes, I have my protection in place, I have a business name registered, a domain registered, and or a company name registered. But none of these are trademarks, and they will not allow you enforce that name against third parties offering a similar good or service under a similar or identical name. And you'll only get that sort of protection by actually applying to register your mark as a trademark. So just to bear in mind, that will not give you trademark rights. So to put it in context, this is just some examples of trademarks. So you'll see the likes of Xerox or Dunn Stores, which would be your common word marks, which you're probably most familiar with. You can also have the likes of, see, the Toblerone packaging as a trademark, so you're getting protection for the word Toblerone in conjunction with how it's actually sold in practice in the triangular box. You'll see the one on the top left is what we refer to as a composite mark, so it's not just a word, it's a word in conjunction with the logo. Oftentimes companies maybe have a fairly descriptive name or descriptive mark, so they maybe add a logo or device element to add some level of distinctiveness to the overall mark. Other options available, you'll see top right is just a colour combination mark, so it's literally just the colour yellow and the colour red. That's sort of falling into the realm of sort of more non-conventional marks, which I'll discuss a little bit in the next slide. And they tend to be a little bit more difficult to obtain because in theory you're getting a monopoly to colours, which you know people would argue all should be free to use. And then the Coca-Cola is just an example of a label mark. So it's protection for the words in conjunction with the colours and the logo. So this is just an example, as I say, a particular product that I'm sure you're all familiar with, and just to give you an idea of the number and types of trademarks which could subsist in that particular product. So the Coca-Cola bottle, the shape itself may be capable of functioning as a trademark, but again, generally that will require lots of use. You've the colours, the colour red and white, again, after lots of use that may be functioning as a trademark. Obviously the words, which are the more common type of trademark for Coca-Cola, and then the little swirly device element is a logo type mark. So that's just showing you that any one product can actually have a number of different marks. So I mentioned earlier about the sort of more non-conventional or exotic trademarks, which are becoming a little bit more popular. So you can get trademark protection for a particular sound. So you probably all know the sort of Direct Line Insurance jingle. So how they, I suppose, described their trademark when an application was filed was they actually filed the musical stave with the actual notes. Assuming everyone can read music, which doesn't necessarily sit well with me, but that is deemed to be an acceptable graphical representation of a sound mark. Then you can also have colour marks. Again, you're probably all familiar with Cadbury's purple for chocolate, so they have trademark protection in place. The turquoise colour for Heinz baked beans equally. And then even more exotic are smell marks, and just a couple of examples. Not the most pleasant, the first one, but the smell of bitter beer applied to flights of darts is actually a trademark. And then the smell of fresh cut grass for tennis balls. So people will be filing an actual smell sample, I suppose, at the office is how they're getting their trademark in place. So this is the important part, really, is the best type of trademarks. In practice, we have found that marketing people and companies in general want their product or their trademark or their name to describe what their product is. So they want the public, because there's such a huge array of selection and choice, their thinking is, I want the public to know immediately what my product does or what its advantage, of the actual product. So they tend to pick something that is quite descriptive. But unfortunately, that goes against the whole premise of a trademark. Trademarks shouldn't describe the product. They should be distinctive. So, as I say, the best type of mark is an invented word that has absolutely no meaning in any language. So 2 samples of that would be Kodak and Panadol. So they mean absolutely nothing in relation to cameras or films or pain relief medicines. So they're like the best type of mark. So as I said earlier, you definitely don't want to pick a trademark that just describes your product. So an example of that would be the use of the word fresh for salad foods. So upon seeing fresh on a bag of salad, the public is just going to presume that that product is fresh. They're not looking at the word fresh in a trademark sense. Okay, so if somebody did want to get trademark protection for fresh, they'd probably have to either add a further word that's distinctive or the logo or some kind of stylization that will, the distinctiveness would lie in that and not in the word fresh per se. So, in a nutshell, steer clear of descriptive words from a trademark perspective. Something that is a fanciful version of a word that sort of just alludes to the product but actually doesn't describe it. So just a couple of samples there would be Weetabix, which, in a way alludes to maybe a wheat-containing product that's maybe sold as a biscuit. But again, it doesn't directly describe the product at all. So that's quite a clever mark. And similarly, Tato, which, might suggest the product is made from potatoes, but it certainly doesn't directly describe that as being the case. So that's a clever mark as well. And then another variety of trademark, which is excellent as well, would be a word that has a meaning but has no meaning in relation to your particular product or service. So the example there would be Apple. Obviously it's a common English dictionary word, but has absolutely no meaning in relation to computers. And I'm sure you're all aware that the Apple brand is hugely successful, so that is a good option for a trademark as well. So just a little bit more on choosing your name, because obviously it's very important. You want to make sure that it is distinctive, which I mentioned earlier. You don't want it to just describe your product. So for example, if you wanted to sell orange juice or an orange containing product of some description, don't just have a depiction of an orange, for example, because that would just be held to be totally descriptive. It's, it should be free for all to use. You're not going to get a monopoly in the use of an orange or a picture of an orange for an orange product. Similarly, make sure it's not descriptive, as was already mentioned. So double mint, for example, that upon being applied to a product containing mint could just let the public think, oh, my product is particularly minty or has double the strength of mint. So again, that would be held to be descriptive. You don't want your mark to be deceptive. When I say don't want, it's actually not allowed. I should say the law doesn't allow for deceptive trademarks. So an example there would be Woolies. And if you used Woolies on a clothing item, for example, that wasn't made of wool, you would be held to be deceiving the public. The public would have an expectation that Woolies refers to wool. So you would be deceiving the public in that instance. The law doesn't allow for offensive marks. I haven't put an example up there, but people do try to get marks that are just blatantly offensive on many levels. So again, steer clear of that. and then something that's generic. So marks can become generic over time, aspirin being an example of that, whereby it was a trademark at one point, but maybe wasn't sufficiently policed, or people were just starting to use it generically. Similarly, Hoover, obviously everyone refers to the vacuum cleaner as a Hoover generically now, so you're not going to get trademark protection for something like that. But the main thing that would be advisable is to try and pick a mark that is quite different from competitors. I mean, we would have people would come to us saying, oh, what do you think of this mark? And we might have a little look on the register or on the internet to see is there anything similar out there, and you're bombarded with a lot of highly similar marks, not identical but highly similar, operating in the same arena. And our advice generally would be try and maybe pick something that stands out a little bit more. You don't want to be just more or less the same as a competitor, but a little bit different. Something that stands out and is more memorable is likely to stick in the minds of the relevant public, apart from something that's just very like other things out there already. So how do you achieve your trademark rights, or I suppose protect them as best you can? Primarily, obviously, achieved through registration. So there's an actual process in place, an application is filed, and I'll go through that in a little bit more detail later on. Protection does accrue when you use a particular mark as well. So if you don't actually apply to get your mark registered, but say you have been using it for 10 years or so, you would have built up unregistered rights in the name as well. But they're far more difficult to prove. It's a much more onerous task. If you have a trademark registration in your hand, it's basically prima facie evidence that I own rights to this particular name. If you're relying solely on your unregistered user rights, you have to prove that you own them in the first place. So you're going through this whole task of, I've been using this mark since X date, and here's details of all of my invoices and my sales and my customers and my this and my that. So it's far more onerous to prove an unregistered right. So the advice would be get it registered when possible. And if you do get a trademark registration, you basically have the exclusive right to use that name or logo for certain goods or services. And that's a very important point that I think people don't realise, is that you don't just apply for a trademark. You don't just say, let's say Coca-Cola, for example. You have to specify the particular goods and services that you intend to offer under that mark, so that your monopoly right is restricted to those particular goods and services. So, for example, clients would often contact me, maybe having done a little bit of research themselves, and they're interested in, for example, selling clothing products under a particular name, and they say, oh, but I found a financial institution that operates under the same name, I can't do it. And you have to explain, well, that financial institution doesn't have protection, or their rights generally wouldn't extend to a completely unrelated arena such as clothing. So your rights are limited down to what you have included in your trademark application, and each application has to clearly specify the goods and services which you are offering under the particular mark. So again, I've probably touched on this a little bit through talking the earlier slides, but why should you register your trademark? Well, basically, as I say, it gives you your exclusive rights, so you can stop people from copying your mark. You can stop people registering similar or identical marks, so you can ensure that the registrars aren't getting blocked up with similar marks. Cheaper to prove than unregistered rights, as we mentioned before. If you're relying solely on use, you have to prove that you own rights in the mark based on that use. Generally very onerous, involves collating huge amounts of evidence, etc. So it's far cheaper to just waive your registered certificate of registration at a would-be infringer. And then obviously they're extremely valuable. There's licensing possibilities. You can sell. It's a piece of property, extremely lucrative. I'm sure you're all aware of the branding estimates for the likes of Apple, and I know they're the big guys, but you're talking billions and billions. It's a hugely valuable asset to any company. So if I have you convinced, what are the next steps? First of all, although not compulsory, it is advisable to run a search on availability. And basically this search will highlight, I suppose, if a third party is already using an identical or similar mark in the same or similar arena. So obviously if there is something revealed during those searches, you might have to have a rethink. It's best obviously if these searches are undertaken before you've invested any time and money in marketing and promoting the product. Obviously if you come to us at that stage, the advice has to be tailored, I suppose, from the point of view that you've already invested a huge amount. It's far better coming to us, maybe with a selection of proposed marks and sort of saying, listen, thinking of this, thinking of that, and then we can search and look to see which one appears to be the most available, let's just say. So as I say, pre-filing clearance searches, and then assuming everything's in order or you're willing to take whatever the associated risk is, you apply to register the mark. So why do the searches? Again, not compulsory by any stretch, but advisable. It just gives you an indication as to whether you're free to use and or free to register the mark. How are they done? Various options. Generally, it's certainly a check of the registers. So it's the actual National Trademarks Register in Ireland, the European Register, and depending on where you want to get your protection, the national registers in those jurisdictions as well. Internet searches also tend to give you a good insight into what's going on, and then just knowledge in the trade, and clients are obviously best placed to advise on that front. If a client is very active in a particular industry and isn't aware of anybody else operating under that particular name, you know, that would certainly be something that you would bear in mind when providing your advice. So if you want to proceed, your searches are clear, and you decide, yeah, I'm going to go ahead and file my trademark, or, which often clients do, you just decide, I'm going to file and take the chance. We're often asked, oh, is there such a thing, can I file a worldwide trademark? And the answer basically, I've said not really up there, but it's kind of no. The only way you can get protection throughout the world is if you file nationally in all your countries of interest. The various routes to registration, as I say, you can file nationally, which would be feasible, or I suppose a good option for somebody that's only operating in Ireland. There's regional options, the main one being the European route, where you can file a single application and it gives you protection throughout the whole of the EU. It's far more cost effective than nationals, but it does open you up to potential obstacles coming from all of the EU countries as opposed to just the Irish market. And then there is something referred to as an international trademark, but it's not a single filing which gives you protection internationally. It's essentially gives you the option of selecting up to 90 countries. You can select as many as you wish, and each application is examined as if it was filed nationally. So it essentially gives you a bundle of national rights. Quick overview of the process for most, the trademark application process in most jurisdictions. You apply for your mark, it gets examined in the national office where you've applied. If it's accepted, it's published for opposition purposes, so third parties can decide, I don't like that mark, or I don't want my competitor to have that mark, and they try and stop you getting it. And then if you overcome any obstacles, and or there were none in the first place, the mark proceeds through to registration, and it's then valid for 10 years and can be renewed for subsequent periods of 10 years for as long as you like, essentially. So once you do get your mark registered, you can use the or and the circle symbol, which you're probably all familiar with. Prior to that, you would use the TM, or you can, you don't have to, but people often do use TM, which is essentially giving notice, letting people know I am using this name in a trademark sense, but you don't have registration in place. So that's it in a nutshell.